Hi, good evening. Buenas noches and welcome to Kandit News. I'm Troy Torres. Let's say you and your coworkers came to work and found a request from your boss that said, get together and figure out where we're going to have our next Christmas party. Hyatt or Dusit? You all have to agree, and I need the answer by 5 p.m. So throughout the day, the 12 of you go back and forth on which is the better venue for the Christmas party. By 5 p.m., there's a problem. 10 of you voted for the Dusit. You and another coworker voted for the Hyatt. There seemed to be no way you would change your minds. Your boss wasn't happy about that, so he said there won't be any Christmas party until there's a unanimous decision. How do you think you and the other holdouts voted after that? The American criminal justice system contains a unique parliamentary rule for a decision to be reached. Everyone must vote the same way. Not Congress, the Supreme Court, the College of Cardinals, nor any legislature abides by the rule that selection of a person or position must be done by unanimous vote. Well, there is one exception. In selecting a pope, the College of Cardinals may elect someone from outside its ranks if, inspired by the Holy Spirit, all the cardinals at the same time explain their decision for the election of a man by reciting that man's name. Clement X and Innocent XI's elections resulted from this type of ballot. That's 2 out of 200. Yet verdicts of guilty or not guilty have been handed down by unanimous vote hundreds of thousands of times in this country. The thought process for a unanimous vote is that 12 people, chosen from a pool of your peers, deliberating on the evidence and the evidence alone, will come to the same reasonable conclusion. If the defendant is guilty beyond any doubt of a reasonable person thinking reasonably of the facts before him, then 2 reasonable people from that same pool should find him guilty. And in the case of a trial jury, 12 people should find him guilty. But if there is reasonable doubt, it will manifest in one of 2 ways. Either 12 jurors will issue a unanimous verdict of not guilty, or 1 or more jurors will remain steadfast to their verdict vote of not guilty, and the jury will be hopelessly deadlocked. In order to deprive a person of his liberty, the criminal justice system requires that no reasonable doubt lingers as to his guilt. And then there's the Allen charge. An Allen charge is a supplemental instruction from the judge to the jury that normally occurs after a jury reports to the judge that it is hopelessly deadlocked. Rather than accepting that reasonable doubt appears as to the defendant's guilt, the judge sends the jury back into deliberations with instructions for those in the minority to re-examine their brains and to consider whether they could have been wrong. The precedent for trial judges to have this bullying power over jurors in the minority was set in 1896 in the landmark Supreme Court decision Allen versus United States. It remains a highly divisive topic for jurists on the grounds that it violates a defendant's rights to a fair trial and the sacred foundation of the jury tradition in the United States. In fact, the basis of the Allen charge stems from tactics employed in Europe dating as far back as the 14th century. This is when judges would withhold food from jurors until they reached a verdict in a trial. The practice is thought to be so arcane that 20 states have outlawed the use of the Allen charge by its judges, and so has the 5th Circuit Court of Appeals, but not Guam. At 1:30 p.m. Friday, the jury in the Martinez and Moser trial reported to Judge Francis Siding Gatewood that they were hopelessly deadlocked. Unable to issue a unanimous verdict that the defendants were guilty beyond a reasonable doubt, rather than observing the decision of the jury, the judge issued an Allen charge, forcing the jury to deliberate further and to probe the minority holdouts whether they made the wrong decision. Dissenting in the 5th Circuit appeal of Huffman versus United States, Judge Brown wrote, quote, "I think a mistrial from a hung jury is a safeguard to liberty. In many areas, it is the sole means by which one of a few may stand out against an overwhelming contemporary public sentiment. Nothing should interfere with its exercise. In the final analysis, the Allen charge itself does not make sense. All it may rightfully say is that there is a duty to consider the views of others, but that a conscientious person has finally the right and duty to stand by conscience. If it says that and nothing more, it is a superfluous lecture on citizenship. If it says more to declare that there is a duty to decide, it is legally incorrect as an interference with that rightful independence. The jury, having already decided this case with deadlock, now must return to the deliberation room at 8 a.m. tomorrow, where the minority of its members will be under pressure to reconsider their verdict, not as triers of fact, but of their own conscience. Their ability to reach unanimous verdict is of far greater consequence than a choice between the Ducit or the Heineck. And perhaps that kind of comparison against a far more trite occasion may be the subject of appeal for either side of this trial. So much has happened since the first week of October, when this trial got its start with what was just a ceremonial pre-trial conference. Indeed, much more has happened in the 3.5 years since the federal government began entrapping Raymond Martinez and Martinez Moser on May 1, 2015. And in order to understand why they were entrapped to begin with, Kandit News had to go back to the scandal that started it all, the Customs Corruption Scandal, the one that was so-called masterminded by a man named Henry Alvendia, the former customs official who also happened to be a U.S. customs officer once, serving alongside friends like Erwin Farron and Urfel Matanguin, the federal agents who brought the case against Mr. Martinez and Ms. Moser at the behest of Mr. Alvendia himself. This is why we've called the entirety of these events the Alvendia Corruption Scandal. Everything centers around this one man, who is the federal government's star witness, whom the federal government has insulated and protected at all costs, lying in a federal court through a federal trial, concealing financial records that prove Mr. Alvendia is not qualified for the federal public defender compliments of the American taxpayer, sealing over half this trial and suppressing over half of the evidence relevant to a proper defense, including the undisclosed discovery of the central piece of evidence disproving the existence of any drugs on the couple, and the notebook Mr. Alvendia kept that proves the criminal complicity of the federal prosecutor himself, Assistant U.S. Attorney Fred Black. Now that the jury has returned unable to reach a verdict, the federal judge herself has issued an 1896 court precedent so lowly regarded in the legal system that nearly half the country forbids it. What is the system trying to hide? And what is so important about Mr. Alvendia to all of this that the Department of Justice is willing to protect and reward the most corrupt police officer ever convicted in the history of our island with accolades and freedom? Buried in all of this commotion is the fact that the federal government is going to let this guy go without spending a single day behind bars. So much for the fight against corruption, huh? This conspiracy, not the drug conspiracy, is what demands our attention. Because if it can happen to this couple, then it can happen to any one of us at any moment of our lives. The jury likely has never seen any of these newscasts or the special series we ran on the Alvendia Corruption Scandal. The information we have provided to the public, over half of that was not entered into evidence in the trial. Mr. Black made sure of that. Judge Gatewood suppressed it all. Law enforcement from Guam to California made sure to get their lies straight with Mr. Black on everything else. The jury was commanded each time they left the jury box not to discuss any issue related to the trial with anyone. And the judge was specific in admonishing the jurors to avoid any stories relating to the trial or its subjects on social media. So if that jury returns a not guilty verdict, it will be a testament to a system that works despite the motives of its officers and precisely because the lone holdout for justice in the entire system is a jury of our peers. The system is supposed to incubate the delivery of justice. It is a design of the Constitution brought to life by the mandate of the people under the rule of law. But when its agents corrupt Lady Justice's gestation with its bitter and clever poison concealed in tonics of secrecy and lies, then what we are left with is a miscarriage. If that jury is forced into a guilty verdict, this will be worse than a miscarriage of justice. She will have had an abortion, and no justice will be delivered but a stillborn.